Well, at least one of the January 6th insurrectionists is going to be released from jail
after nearly 6 months pre-trial detention.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, who thinks there's food on the bottom of the floor, but there isn't. This is an update on a couple of stories, one of which has been the, some would say, unjust pretrial detention of a number of the accused and arrested from the January 6th riots.
I'm calling them a riot.
A number of those accused and arrested, and some would probably rightly say way too many, have been in pretrial detention ever since the events, and we are now we're not nearing 6 months, we're nearing 8 months of pretrial detention for some. This story brings up issues of constitutional rights, fake news, and what happens when the prosecutorial process gets heavily weaponized. From the Washington Post, legal issues. Man charged in Jan 6 assault on Capitol Police Officer Brian D. Sicknick ordered released. By Spencer S. Shue, a 3-judge appeals court panel has ordered the release of West Virginia sandwich shop owner George Tanios pending trial in the January 6 chemical spray assault on 3 police officers, including Brian D. Sicknick, who died the following day after suffering 2 strokes. A lower court, quote, clearly erred in its individualized assessment of appellant's dangerousness, end quote. The judges from the U.S. Circuit Court of Appeals for the D.C. Circuit said in an order filed Monday night. Quote, the record reflects that Tanios has no past felony convictions, no ties to any extremist organizations, and no post-January 6 criminal behavior that would otherwise show him to pose a danger to the community within the meaning of the Bail Reform Act, end quote, the panel's order said. Both men who have pleaded not guilty have been jailed since their arrest in March, when they were arrested on 9 counts, including in the assaults on Sicknick, a fellow Capitol Police officer, and a D.C. officer. Now, before we get into the constitutional issues, before we go over the court order, it's a very short court order in the first place. We have to deal with the fake news aspect of this story. Even now, they are trying to frame this story as though the accused had something to do with the death of Officer Brian D. Sicknick. This is the narrative they are still trying to push months later after it was revealed that Brian Sicknick, in fact, did not die of any injury sustained during these riots. He died of 2 strokes, but his death, to say that his death was politicized by the mainstream media would be the understatement of the week. From the New York Times, he dreamed of being a police officer, then was killed by a pro-Trump mob. The death of Brian Sicknick, a military veteran and experienced Capitol Police officer, amplified the tragedy of Wednesday's riots and undermined President Trump's pro-law enforcement claims. This is none other than the New York Times saying that Brian Sicknick was killed by a pro-Trump mob, and this is not an archived old article that you can no longer find on the internet. This is still the article that you will find on the internet if you Google these terms. But, you know, because the New York Times is responsible real news, they've updated their article with the following update. By Zolan Cano-Youngs and Tracy Tully. Update. New information has emerged regarding the death of the Capitol Police officer Brian Sicknick that questions the initial cause of his death provided by officials close to the Capitol Police. The New York Times update regarding the emergence of new information that questions the cause of death of Brian Sicknick is dated March 24, 2021, but it has since been revealed and confirmed that Brian Sicknick died of natural causes, 2 strokes, and yet this article is still online. This article is still online with a discrete update that still does not tell the entire truth, and when you read the article, it becomes clear that the New York Times is fake news. Then on Wednesday, pro-Trump rioters attacked that citadel of democracy and overpowered Mr. Sicknick, 42, according to 2 law enforcement officials. With a bloody gash in his head, Mr. Sicknick was rushed to the hospital and placed on life support. He died on Thursday evening. Law enforcement officials initially said Mr. Sicknick was struck with a fire extinguisher, but weeks later, police sources and investigators were at odds over whether he was hit. Medical experts have said he did not die of blunt force trauma, according to 1 law enforcement official. Good sir, thank you very much. Thank you.
Welcome back.
Thank you very much.
Mailman.
And because fake news is what it is, when it gets caught with its hand in the fake news cookie jar, what does it do? It does not apologize, it just doubles down in order to continue to promote the narrative. Instead, investigators increasingly believe that a factor may have been an irritant such as mace or bear spray that was sprayed in the face of Mr. Sicknick, the law enforcement official said. The Capitol Police said in a statement that Officer Sicknick died from injuries sustained, quote, while physically engaging with protesters, end quote. Quote, Brian is a hero, end quote, his brother Ken Sicknick said. Quote, that is what we would like people to remember, end quote. Brian Sicknick is in fact a hero. Any police officer that carries out their duties with diligence and honor is a hero. Anyone in the military who does the same is in fact a hero, and they deserve to be treated like a hero,
not exploited by fake news for narrative purposes.
With that said, on to the constitutional side of this vlog, because the US Constitution has a certain 8th Amendment which prohibits cruel and unusual punishment and excessive bail. 8th Amendment, excessive fines, cruel and unusual punishment, passed by Congress September 25, 1789, ratified December September 15, 1791, the first 10 amendments from the Bill of Rights. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This is not a question of semantics, this is just basic common sense. There can be no more excessive bail
than no bail whatsoever.
Call the events of January 6th whatever you want, call it a rowdy riot, call it a protest, call it an insurrection for all I care. The fact of the matter is that there are individuals who were arrested on that day or shortly thereafter that have been in pretrial detention since, whereas in other circumstances, I don't know, say like the Governor Whitmer kidnapping plot, the FBI agent who is accused of domestic violence, serious domestic violence, was released on his own recognizance and $10,000 bail. There are very specific reasons for which bail should be denied, and as far as I'm concerned, nothing that occurred on that day could possibly justify 6 months of pretrial detention. No bail is excessive bail, and excessive bail is unconstitutional, and what is being done to those accused is purely unconstitutional. With that said, let's get to the order itself. It's very short. We already read a portion of it in the intro article, but the last paragraph is somewhat interesting of this order. United States Court of Appeals for the District of Columbia Circuit, United States of America, Appellee versus George Pierre Tanios, Appellant. On appeal from the United States District Court for the District of Columbia, before Henderson, Rogers, and Walker, circuit judges. Now, whether we like it or not, we have to do this exercise pretty much every time, so I went and looked into the judicial appointment history of these judges, and it would seem that 2 of them were appointed by Ronald Reagan, 1 of them was appointed by Donald Trump, and I hope I got the 3 judges right, because I just hope that there are not other judges with those names on the same circuit. So there you have it. If you are inclined to write this court order off as a politically motivated court order, you have the fodder to do it. Now let's just read the court order itself. This appeal was considered on the record from the United States District Court for the District of Columbia and on the memoranda of law and facts filed by the parties. See District Court Circuit Rule 36. It is ordered and adjudged that the District Court's May 12, 2021 order be reversed and the case remanded for the District Court to order appellant's pretrial release subject to appropriate conditions, including home detention and electronic monitoring. On this record, we conclude that the District Court clearly erred in determining that no condition or combination of conditions of release would reasonably assure the safety of the community. Then we have the portion of the order that we already read in the beginning of this vlog. In the article summarizing the story, bottom line, the judges came to the conclusion that there was no evidence in the court record to suggest that the defendant posed a risk to the community. But it's the last paragraph that I didn't know what it meant, and I had to go pick the brains of certain American lawyers who definitely know this subject matter better than I do, but let's just read that paragraph. Pursuant to DC Circuit Rule 36, this disposition will not be published. The court is directed to withhold issuance of the mandate herein until 7 days after resolution of any timely petition for rehearing or petition for rehearing en banc. So from what was explained to me, the last portion of that paragraph indicates that the court is basically giving a 7-day delay within which to appeal or petition for a rehearing en banc, but the fact that this order is not going to be published means that it will not have precedential value. They're just basically sending this back to the judges to make the proper decision. So I guess in a judicial way, everyone gets a little something out of this. It goes back to the judges to make the proper decision, whereas this decision itself will not have any lasting precedential value, but at the very least, the defendant is going to potentially get out of jail
After 7 months.
7 months pretrial detention for someone who apparently had no priors and, according to the court, did not pose any danger to the community, has been sitting in jail for 7 months pretrial detention. It doesn't matter what side of the political aisle you sit on, this should shock and offend everyone. Justice delayed is justice denied, and 7 months pretrial detention is excessive bail by definition. And with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Feed me Seymour.
If you want to support the channel, all the support links are in the pinned comment. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. We are also on Locals. If anybody wants to find us and support us there, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah! Did you like that vlog? Was it interesting? Did you learn something?